Jody. We're live on YouTube. We are getting ready to have an adjudication disposition hearing. I missed it. Do you mind, could you take that to Mary? Tell her in lieu of a DTA, we'll just schedule a out of custody. Thanks. Mr. Beaver and Ms. Smith, thank you for being so understanding this morning and agreeing to reschedule this for this afternoon.
Thank you, Your Honor.
Y'all know, are we proceeding on the entirety of the state's petition filed April 24th?
Yes, Your Honor.
Yes, Your Honor, that's my understanding.
All right. Okay. Thank you, Ms. Coles, for agreeing to come back. I appreciate it.
I look irritated, but not at y'all at all. This is his fault. He chose for us to be here.
Well, I appreciate your understanding. So, Ms. Aguirre, are they bringing Mr. Marshall up?
Yes, Your Honor, I believe so, but I'll call detention to verify.
All right, thanks.
Your Honor, they are bringing him right now.
Thank you.
One of the staff had stuff on the other thing. That's on the one over. All right.
Good afternoon. It is Monday, May 11th, 2020. We are here in cause number 323-113578-20 in the matter of Zachariah Dwayne Marshall. Are you Mr. Marshall?
Yes, Your Honor.
What is your date of birth?
It is 02/23.
What year?
06.
All right. That makes you how old?
14.
All right. I'll let the parties know because the respondent is over the age of 14 years of age. This hearing is being broadcast on YouTube to comply with the open courts provision of the Texas Constitution. Because the Supreme Court has ordered our courtrooms closed, but we still want to comply with the spirit of the Texas Constitution, we're broadcasting this hearing on YouTube. Any broadcast or rebroadcast or recording of this hearing by anyone, anywhere, is expressly prohibited by order of the court. Failure to abide by the court's order in this respect will subject the person to civil and/or criminal contempt. Are both sides ready to proceed?
It's ready.
Respondent is ready, Your Honor.
All right. Actually, Mr. Beaver, first, I have before me a document titled State's Disclosure of Documents, Items, and Information Provided to the Respondent. Are you satisfied with the discovery provided by the state in this case?
Yes, Your Honor, I am.
All right. Now, Mr. Marshall, before we can proceed, I've got to go over several things with you. First, you have the right to have this hearing in front of Judge Kim. But if you'd like to proceed today, you can have it in front of me. Would you rather have it in front of me or in front of Judge Kim?
In front of you, Your Honor.
Okay. And Mr. Beaver, do you join your client in waiving his right to a hearing before the district judge?
Yes, Your Honor, I do.
All right. Now, Mr. Marshall, the United States Constitution, the Texas Constitution, and our state laws give you several very important rights, and I need to go over all those with you. First, you have the absolute right in your two cases to have a jury trial, or actually, you just have one case, but it has two different charges. And a jury trial would be where a group of citizens from the community were brought into the courthouse, and your lawyer would work with me and the prosecutor to pick 12 of them. And those 12 people would decide whether or not you actually did what the state has accused you of doing. As part of a jury trial, you could force the state to call in all the witnesses who might testify against you. You would get to look them in the eyes. And then your attorney would get to cross-examine them to make sure they're telling you the truth. Do you understand that?
Yes, Your Honor.
All right. But if things proceed, as I believe they will today, there won't be a jury trial. Do you understand that? And instead of 12 people deciding whether or not you actually did what the state's accused you of doing, it'll all be decided by me. You understand that?
Yes, Your Honor.
Is that what you want to do? You want to give up your right to a jury trial?
No, Your Honor.
Do you want a judge? Do you want me to decide it, everything, or do you want a jury to decide this case?
You, Your Honor.
Pardon?
You, Your Honor.
Okay. So you wish to give up your right to a jury trial, correct?
Yes.
All right. And Mr. Beaver, do you join your client in waiving his right to a jury trial?
Yes, Your Honor, I do.
All right. Mr. Marshall, our law also gives you the absolute right to remain silent and not say anything at all. Nobody can force you to take the witness stand and confess to doing what the state has accused you of doing. You understand that?
Yes, Your Honor.
But if you want, you can give up that right and you can admit to doing what the state has accused you of doing, but nobody can make you do that, okay? Now, if things proceed as I think they will today, I'm going to ask you in a little bit if you want to give up that right to remain silent, okay? And then I'll ask you whether or not you actually did what the state has accused you of doing. If at any time you don't understand what's going on, or if you want to talk privately with your attorney, wave your hand like this. That'll get my attention and it'll get your attorney's attention. And I will create a special internet chat room that only the two of y'all will be in, and y'all can talk about that, okay? Does that make sense? Okay, I need you to answer out loud for me, Mr. Marshall.
Yes, Your Honor.
All right. Okay. Mr. Marshall, are you an American citizen?
Yes, Your Honor.
Where were you born?
I was born in Texas,
All right. What city in Texas?
Fort Worth.
Fort Worth, Texas. Okay. I know it's silly, but I have to ask that question of everybody who comes to court, okay?
He was born in Galveston.
All right. For the record, the court will note that Ms. Coles, the respondent mother, interrupted and offered that. And the court thanks Ms. Coles for her input. But at this time, I have to have just a dialogue between myself and Mr. Marshall, okay? Thank you. All right. Now, I have before me a document titled Stipulation of Evidence, Judicial Confession, and Disposition Agreement. It's pretty long, Mr. Marshall, 2 pages. It requires me to go over the entire thing with you, line by line, okay? So I want you to listen very carefully. And then at the end of each paragraph, I'm going to ask you if you agree with it or if that paragraph is true, okay? Is that a yes? Do you understand, Mr. Marshall?
Okay.
Okay, Mr. Marshall, pull your chair a little closer to the computer. All right, and I'm going to need you to speak up a little bit louder, okay?
All right.
Thank you. All right. To the Honorable Judge of said court, may it be agreed and stipulated between the parties in the above styled number cause of action in which Zachariah Dwayne Marshall is the respondent the following facts. First, if the witness, Gwendolyn Coles, were in court and testified under oath, she would testify that they reside at, I'm not going to say the house number because this is being broadcast on YouTube, but at a specific address on Vela Lane at a specific number in Fort Worth, Tarrant County, Texas. Is that statement correct? That y'all reside on Vela Lane? Mr. Marshall, is that a yes? Okay, Mr. Marshall, I can't hear you.
Yes, Your Honor.
There we go. There we go. Okay. Ms. Coles would further testify that she is the parent of the respondent in this cause, that the respondent's name is Zachariah Dwayne Marshall, and that he is a male child, 14 years of age, having been born on the date of birth you gave me previously. Is that all correct?
Yes, Your Honor.
And the witness would also testify that she is the person who has custody and control of the respondent in this case. Is that correct?
Yes, Your Honor.
Okay. Next, I, Zachariah Dwayne Marshall, the respondent in the above entitled and numbered cause in writing in an open court, consent to the stipulation of evidence in this case, and in so doing expressly waive the appearance, the confrontation, and the cross-examination of witnesses, the right to a trial, and the right to a trial by jury, and further consent to the introduction of testimony by affidavits, written statements of witnesses, and other documentary evidence. Accordingly, having waived my federal and state constitutional rights against self-incrimination, and after having been sworn upon oath, I judicially confess to the following facts, and agree and stipulate that the facts are true and correct and constitute the evidence in this case. Okay. What that paragraph means is I'm about to ask you whether some facts are true or not true, okay? And if at any time you disagree with them or you don't feel comfortable going forward, you say so, okay?
Yes, Your Honor.
All right, first, I was born on the date of birth we discussed earlier, and you live in Tarrant County, Texas. Is that true or not true?
That is true.
Okay. Second, on or about the 10th day of March, 2020 in Tarrant County, Texas, I did intentionally operate a motor vehicle, namely an automobile, knowing that I did not have the effective consent of the owner, Charlotte Kennel. Such conduct is a state jail felony and violates a penal law of the state of Texas punishable by imprisonment or confinement in jail, more specifically, Section 3107 of the Texas Penal Code, and is delinquent conduct as defined in Section 51.03A of the Texas Family Code. Essentially, what that paragraph says is you're admitting that you committed the offense of an authorized use of a motor vehicle on March 10th of 2020. Do you understand that charge?
Yes, Your Honor.
Is that charge true or not true?
True.
Okay, next paragraph. Fourth, on or about April 23rd, 2020 in Tarrant County, Texas, I did intentionally flee using a vehicle from T-Volk, knowing T-Volk was a peace officer who was attempting to lawfully arrest or detain me. We commonly call that crime fleeing an officer using a vehicle. Okay, that conduct is a third-degree felony and violates a penal law of the state of Texas punishable by imprisonment or confinement in jail, more specifically, Section 3804 of the Texas Penal Code, and as delinquent conduct as defined by Section 5103A of the Texas Family Code. Do you understand that charge?
Yes, Your Honor.
And is it true or not true that on or about April 23rd of this year, you fled from a peace officer using a vehicle?
That is true.
Okay. Now, with respect to both of those allegations, are you pleading true today? Because that's what you want to do.
Yes, Your Honor.
Did anybody force you to do that?
No, Your Honor.
Did anybody trick you into doing it?
No.
Did the President of the United States call you back last night in detention and promise you $1 million and a full presidential pardon if you came in here and pled true today?
No, Your Honor.
So the only two reasons you're pleading true is because A, that's what you want to do, and B, because it in fact happened, right?
Yes, Your Honor.
Okay. Okay. Final paragraph. I, Zachariah Dwayne Marshall, further agree and stipulate that I am a child in need of rehabilitation, or that the protection of the public requires the disposition be made. I further agree to a disposition of 12 months probation with the following conditions: participate in a drug assessment and complete any recommended treatments, submit to random urinalysis, have no contact with, is it Trakenan Sims? Am I pronouncing his name correctly?
No, it's true, Kenan.
Okay. Kamari Jones and Tyron Elsie. Okay. You know who those three people are?
Yes, Your Honor.
Okay. And then pay $213 in restitution to Charlotte Kennel and any additional reasonable conditions assessed by the court. Okay. Now, finally, if there's an agreement in this case between you and your attorney and the prosecutor, and if I follow that agreement, you give up one more very important right. That's the right of appeal. That's where a different court located in downtown Fort Worth would look at what we do here today to make sure it was all done correctly. But if there's an agreement between you and the prosecutor regarding the outcome, and if I follow that, there won't be an appeal. Do you understand that?
Yes, Your Honor.
All right. Now, knowing all that we've gone over, knowing that you're giving up all your very important constitutional rights, knowing that if I follow this agreement, you give up your right to an appeal, you still wish to plead true today.
Yes, Your Honor.
All right. I need to tell you one more thing. Because you have 2 felonies in this case, this could follow you in the future. If you ever get in trouble as a juvenile again, the state could use this against you in that future juvenile hearing. You understand that?
Yes, Your Honor.
In fact, if you pick up another felony, that third felony series that you're looking at, you could be looking at what we call a determinate sentence. Anywhere from 10 to 40 years that starts out in the juvenile prison and ends up in the adult prison. Do you understand that?
Yes, Your Honor.
And also, this could track you not just as a juvenile, but later on if you ever get in trouble as an adult. Do you understand that?
Yes.
Now, knowing that risk, do you still want to go forward today?
Yes, Your Honor.
Okay. Mr. Beaver, you've had a chance to get to know your client for a while. Do you have any reason to believe that he lacks a factual as well as rational understanding of the charges against him?
No, Your Honor, I do not.
And do you believe he understands what he's doing here today and all the consequences?
Yes, Your Honor, I do.
All right. Does either side believe there are any additional admonishments need to be given to the respondent at this time?
No, Your Honor.
No, Your Honor.
All right. Mr. Marshall, based on our discussion here this afternoon, I find that you are competent to proceed in this matter. I find that you did engage in delinquent conduct as alleged in the state's petition in this matter. I will find both allegations in paragraph 1 and paragraph 2 to be true, and that will be the order of the court.
Thank you, Your Honor.
Cause number 323 1-1-3578 in the matter of Zachariah Dwayne Marshall. The court takes judicial notice of the contents of the court's file, as well as all hearings over which the court has personally previously presided. The court takes judicial notice that this hearing is occurring by Zoom meeting, and the respondent's parent or guardian is present in the parent room, and both sides counsels are present also by video conference, and as is the juvenile probation officer and the respondent. Are both sides ready to proceed regarding disposition?
State's ready.
Respondent is ready, Your Honor.
All right, state.
State would offer petitioner's exhibit number 1, the social history, and petitioner's exhibit number 2, the victim court report.
Mr. Beaver, have you had a chance to review both petitioner's exhibit 1 and petitioner's exhibit 2 prior to today's hearing?
Yes, Your Honor, I have, and I have no objection.
All right, are you aware of any additions, corrections, or deletions that need to be made to either document?
No, Your Honor.
Petitioner's exhibit 1 will be received and admitted into evidence. Petitioner's exhibit 2 will be received and admitted into evidence. Who would the state call as its first witness?
State would call Selena Aguirre.
All right, Ms. Aguirre, you may remain seated, but please raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Ms. Aguirre, if you will move just a little bit closer to your computer so that your microphone can pick it up. All right, Ms. Smith, you may proceed.
Thank you, Your Honor.
And Ms. Smith, if you will also speak up just a little bit.
Okay. Ms. Aguirre, how are you employed?
I'm employed as a court intake officer for Tarrant County Juvenile Services.
And are you the person who put together petitioner's exhibit number 1, the social history?
Yes, ma'am.
Okay. And the respondent, Zachariah Marshall, he's your client?
Yes, ma'am.
Okay. I just briefly want to go through the social history. Other than these 2 offenses, has he previously been referred or been on supervision through the department?
No, ma'am.
Okay. Who does he currently live with?
Zachariah is currently residing with his mother, Gwendolyn Coles.
Okay. And has Ms. Coles indicated to you that she would like him to come back home and remain in the community?
Yes.
Okay. Does the respondent attend school?
Yes. At this time, they're closed, but online.
Okay. And is that through Eagle Mountain Saginaw Independent School District?
Yes.
Okay. Does the respondent have any substance abuse history?
Yes.
Can you tell us a little bit about that?
According to Zachariah, during his intake, he revealed that he smokes marijuana approximately 3 times every 2 weeks. And when he came back into detention, he tested positive by urinalysis April 24 for marijuana, solely marijuana, no other controlled substances.
Okay. With everything that you have learned and looking at the social history, what is your recommendation to this court?
The department recommends that Zachariah complete a substance abuse evaluation and follow any recommendations by the substance abuse counselor.
Okay. And do you think that it is in Zachariah's best interest to be placed on probation and to return back to his mother?
Yes, ma'am.
I'll pass the witness.
Mr. Beaver?
Thank you. And Ms. Aguirre, how often have you had an opportunity to visit with Mr. Marshall?
I've been able to talk to Zachariah twice a week on the phone.
Okay, great. And in your opinion, do you believe that he understands what he's agreeing here to today?
Yes, sir.
Okay. I pass the witness, Your Honor.
Redirect.
Nothing further.
May this witness be finally excused by both sides.
Yes, Your Honor.
Yes,
All right.
Your Honor.
Who would the state call as its next witness?
The state would rest.
All right, Mr. Beaver.
I would call the respondent's mother, Your Honor.
All right. All right, Ms. Coles, you'll sit up for me, please raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you may proceed, counsel.
Thank you, Your Honor. So, Ms. Coles, you and I have spoken before, is that correct?
Yes,
And you are asking the court to release your son to you so that he can live with you again, is that correct?
right. Yes,
And you have been more than clear with your son as far as your expectations for him when he lives with you, is that correct?
yes,
So, and you believe it's in your son's best interest to go home with you today?
yes.
Okay, I pass the witness, Your Honor.
I have no
State.
questions.
May this witness be finally excused by both sides.
Yes, Your Honor.
Yes, Your Honor.
Who would the respondent call as his next witness?
The respondent rest, Your Honor.
All right. Rebuttal, state.
I don't have anything.
All right, both sides rest and close.
Yes, Your Honor.
Yes, Your Honor.
Summation.
Your Honor, state would just ask that you follow the stipulated agreement as laid out previously in the stipulation paperwork.
Counsel.
And Your Honor, the respondent also requests that the court follow the stipulation agreement.
All right, if you'll give me just a little bit, I've been trying to go through the social history as we're going. Give me just a little bit to finish it up. All right. Mr. Marshall, I find that you are a child in need of rehabilitation. I further find that granting probation will be in your best interest as well as the best interest of the community. I will follow the agreement of the parties in this case. That means you will have no right of appeal. However, as your conditions of probation, it will be following. First, 12 months, as agreed. I'm going to waive any probation fees. I'm also going to waive court costs in this case. You owe $213 in restitution to the victim for the paint scratches, right?
Yes, Your Honor.
Okay. You have to go to school as a condition of your probation. I know it's all kind of up in the air right now, but this fall, when you get back to normal school schedule at Eagle Mountain, Saginaw, you got to be every day. You can't skip class, okay? You skip class, that's a violation of probation, right?
Yes, Your Honor.
Okay. I want you to complete a substance abuse evaluation and follow up with any treatment if indicated. As a result of the evaluation, you will have random UAs during the period of your probation. That means if your probation officer calls you at 9 in the morning, you got to come give a UA. And guess what? She can also call you at 4 o'clock that afternoon on that same day. So you can't think you get away with one at lunchtime and go out and smoke a blunt and think you're good for the next 30 days because she could call you back for a second one in the same day, right?
Yes, sir.
Okay, that's going to help you keep straight and narrow. No driving a vehicle on a public roadway during the entire period of your probation. Not even with your mother's permission, okay? You're 14, you can't have a driver's license yet, right?
Yes, sir.
Okay. No contact with your co-respondents. We already went over their names. I see that mom already has a 10 p.m. curfew. Good job, mom. So I'm going to continue that 10 p.m. curfew. The only exceptions of that are school or religious activities, or if there's something else that you want to be able to get out past 10 o'clock, you've got to get your probation officer's permission in advance. So for example, you and your friends want to go see a big movie and mom's okay with it. Say you want to go see a big movie on a Saturday night, but it doesn't start until maybe 8:45, which means it doesn't get out until 11 o'clock. You have to get Ms. Aguirre's permission in advance, okay?
Yes, sir.
So you got to plan that out. And you have to get permission of both Ms. Aguirre and your mom. If either one of them says no, that's the end of it, okay?
Yes.
All right. I'm going to waive any parental community service, but you will have 48 hours of community service that you have to complete in the next year. That's just 4 hours a month, okay? 4 hours a month for 2 felonies. That's actually pretty light for me. So anything else from either side?
No, Your Honor.
Not from the respondent, Your Honor.
All right, that'll be the order of the court. Thank y'all.
Thank you.
Thank you.
Thank you much.
Thank you, Judge.